You will hear two major classes of questions. The first class attempts to discredit you, either personally or professionally. The second class of question seeks to trick you into either telling the other attorney something useful or making a technical, legal, or simply verbal error. Lawyers will often meet you in a predisposition conference or a pre-trial conference to review the case. A common tactic that opposing attorneys use is to create the impression that you knew the exact questions and that you were coached by your retaining attorney with the desired answers. You have to deflect those questions with responses that counter the suggestion. For example, here's a possible sequence of questions you may hear, along with some effective answers. Question: Mr. Expert, did your counsel tell you the questions he was going to ask before you came here today? Answer: we reviewed the subject areas that I would be testifying on. Question: he told you the questions he would be asking, didn't he? Answer: I didn't know the specific words in his questions. I knew the general subjects of the questions. Question: you told him what answers you would be giving, didn't you? Answer: discussing testimony is pretty normal for a pretrial conference. I just restated the opinions that I would be testifying to in court today. So, direct attacks on your honesty or integrity are not as likely in general as subtle ones. For example, asking how much money you make as an expert witness is a common technique used to create a bit of distance between you and the jurors, at least psychologically. Attorneys will also sometimes ask whether you always work for defendants or for plaintiffs in your legal work. Some of you may in fact prefer to work for one side or the other in most of your cases. If this becomes a pattern, though, you need to prepare for attorneys who will try to establish that you do have a bias toward plaintiffs or toward defendants in general, and therefore, in this case in particular, with the kind of answers and work you do and offer. In the beginning of your expert witness career, much of your work may come from one law firm or even from the same attorney. The opposing counsel may similarly claim that you are biased in favor of this client who seems to hire you frequently for your opinion. Your best defense here would be to reiterate your neutrality in the matter and to reiterate the thoroughness of your investigation, the reliability of your methodologies, and the objectivity of your opinions. Naturally, you should come into any testimonial setting with knowledge at your fingertips of your own prior casework experience. You should have a recollection of roughly how many cases you have worked, how many times you have testified, and what percentage of the time you have worked for the plaintiffs or the defendants. Those will be common questions that you will be asked. The opposing attorneys will often simply try to attack your own ethics or your integrity. Let me alert you in advance to some trick questions that do that and try to attack your credibility through it. First, attorneys may try to make the jury perceive that your integrity is questionable. For example, here is a standard question used to suggest that the other side has bought your opinion. Question: how much are you being paid per hour to deliver your opinions today? You will need to correct this misleading suggestion that your side has paid for you to testify in a particular way. You want to tell the jury that you were hired to provide objective opinions about the facts in the case. For example, a good answer would be, I'm not being paid to deliver or testify to my opinions. I'm being paid for my time, knowledge, and expertise. My opinions are completely my own, and my fees for service are independent of the outcome of the case. My company bills my time out at $300 per hour, or whatever your rate is. Now, if your reputation or expertise leads to well-paid expert witness jobs, you may begin to hear questions like this. At your rate of $300 per hour, Mr. Expert, you must testify a lot in court. Now, if your answer to this question is yes, you have to be prepared for the follow-on allegation that you are a professional expert, doing this primarily, if not solely, for the money. Your best defense is to redefine the reason for your retention. Something like this. I like to think that I have been retained several times because of my knowledge and experience, as well as my reputation for professionalism and objectivity. A key tactic, then, is that attorneys can make frontal attacks on your credibility at any time. You should not appear startled by even rude or abusive questioning tactics. Jurors will give you the benefit of the doubt if you just calmly and simply correct any misstatement by the opposing attorney.